Have you ever heard the phone ring at an odd hour and felt your heart skip, fearing it might be the call that changes everything? I remember getting such a call years ago about my dear friend Howard, who was like a father to me. Howard was 78 at the time, full of life and stories about his younger years. Always the kind of person who kept spare candy in his pocket to hand out to neighborhood kids. One evening, he took a bad fall. Although he recovered, what happened next turned out to be far more painful than any broken bone could ever be. You see, Howard had assumed, like so many of us do, that his estate planning was good enough. He had a simple will he'd written years ago, and he believed that was all he needed. But after his fall, when it came time to update his documents and place certain assets into a trust, he realized he'd let his affairs become a tangled mess. Outdated beneficiary designations, no advance medical directive, confusion among his adult children about who was in charge. Each oversight gradually snowballed into a torrent of legal and emotional headaches for everyone involved. Arguments flared, old sibling rivalries resurfaced, and suddenly the once cozy family gatherings felt fraught with tension. The worst part was seeing Howard in his hospital bed, worried sick that his family would be torn apart by paperwork and disputes. He said something to me that night I'll never forget. I thought I had more time. It struck me how often we put off our own important planning, trusting tomorrow will be a better day. But the truth is, waiting or overlooking small details can cost you your legacy, your peace of mind, and the unity of the family you love. That's why we're going to talk about 6 crucial estate planning mistakes that too many people over 65 are still making. If you stick with me, I'll not only explain what these common pitfalls are, but also show you how to dodge them. Think of it as closing the gaps you never knew existed, so your loved ones aren't left to pick up the pieces at the worst possible time. By the end, you'll have a roadmap that can spare you and your family a lot of heartache, stress, and financial drain. And here's the best part. Some of these fixes are simpler than you think. You don't need to become a legal expert to protect yourself and your loved ones from these hidden landmines. All you really need is to be aware of what's at stake and to take a few proactive steps. The last mistake we discuss is the one that surprised even me, and it could mean the difference between a legacy of gratitude or years of resentment. I speak not just from personal observation, but also from countless conversations with attorneys, financial planners, and seniors who face these challenges head-on. Their experiences, combined with my own, have shaped this practical guide. I'm here to share what I've learned so you won't have to say, I thought I had more time. Before we dive in, please take a moment to subscribe if you haven't already and tap the notification bell so you won't miss any future videos. If you find these insights valuable, type 1 in the comments. If you don't, type 0 so I know to make better videos that truly help. Now let's walk through the 6 estate planning mistakes you want to avoid and reveal how to set things right before it's too late. Mistake number 1, assuming your will is enough. It's tempting to believe that having a simple will is all you need. Many seniors cling to the notion that a standard will, often written decades ago, is the ultimate safety net. But here's a hard truth. Relying solely on a will can leave your loved ones mired in legal complications and possible family disputes. But I have a will, you might say. Doesn't that cover everything? Not necessarily. A common misconception is that a will automatically addresses every scenario: health crises, unexpected changes in family circumstances, or shifts in tax laws. In reality, a will is often just one piece of a broader puzzle. Without up-to-date beneficiary designations and tools like trusts or powers of attorney, the best intentions can unravel. Assets may end up in probate for months or even years. Meanwhile, your family, already dealing with the emotional toll of losing you or caring for you, has the added burden of navigating endless legal hoops. Consider Althea, a 72-year-old who believed she had done everything right by drafting a will in her early 60s. It named her 2 daughters, Janet and Lori, as co-executors. What Althea never updated, however, was the life insurance policy she had taken out in her 40s, which still listed her deceased brother as the beneficiary. When Althea passed away unexpectedly, the mismatch between her will and her outdated life insurance beneficiary caused a tangled mess. Her daughters had to fight for months to correct the beneficiary details. This opened the door to legal headaches that drained both their energy and finances, and the emotional stress put a wedge between them at a time when they should have been leaning on each other for support. The surprising reality is that your will does not always override the beneficiaries named on your insurance policies, investment accounts, or even certain bank accounts. Those beneficiary designations typically take legal precedence over what a will says. This means a single oversight from years ago can derail all your carefully planned intentions. What should you do instead? Start by reviewing every financial product that requires a named beneficiary, life insurance, retirement accounts, annuities, and make sure they're all in sync with your will and current wishes. If you haven't already, consider setting up a living trust for specific assets. Trust can bypass probate, offering a smoother, more private transition of assets. As your life circumstances change, review these documents regularly, at least every few years or after any major life event such as births, deaths, or divorces in the family. Imagine the relief of knowing everything aligns seamlessly: your last will, your insurance policies, and your trusts. You spare your family from the painful process of probate and legal disputes. Ultimately, that's the emotional payoff, ensuring your loved ones can focus on healing and honoring your memory rather than deciphering scattered paperwork. It's about giving them peace of mind at a time when they need it most. Mistake number 2. Failing to assign power of attorney properly. One of the scariest but most essential aspects of estate planning is deciding who will step in if you're no longer able to make decisions for yourself. Too many seniors assume their spouse or oldest child will automatically handle everything, but that's not how the law works. Without a clearly designated power of attorney, POA, even simple financial or medical tasks can become bureaucratic nightmares. A misleading belief is that naming a power of attorney is an admission that you're on the decline. In reality, you're not forecasting your incapacity. You're preparing for the unexpected. We've all heard it said, "I'm doing great now, so I'll deal with that if and when it happens." That's where the danger lies, because if something does happen, like a sudden stroke or an accident, your family might find themselves powerless to act in your best interests if the correct legal documents aren't already in place. Let's talk about Marvin, who is 80 and proud of his sharp mind and active lifestyle. He does daily crossword puzzles, golfs twice a week, and even does volunteer work. Despite warnings from friends, Marvin never set up a durable power of attorney because he felt it was too negative and might attract bad luck. Well, last year he was in a minor car accident that left him with a severe concussion. For nearly a month, Marvin struggled with confusion, unable to pay bills or sign important medical forms. His daughter Jessica wanted to step in, but without a legal POA, she found herself locked out of her father's financial accounts and unable to authorize certain treatments on his behalf. The result? Late fees, missed mortgage payments, and delays in Marvin's health care. Here's the surprising insight. Establishing a power of attorney isn't just about giving someone else control over your life. You can tailor your POA to activate only if you're deemed mentally or physically incapable of making decisions. It's a safety net, not an immediate handover of your independence, and you're free to revoke or revise it as circumstances change. The practical step is to consult an attorney or a reputable online legal service if you prefer, to draft both a financial and a healthcare power of attorney. Make sure the person you choose is someone you genuinely trust, who understands your values and respects your wishes. Talk to them openly about your preferences. How aggressive do you want medical treatments to be? How important is it to you to keep your home if you ever need assisted living? By setting these guidelines in writing, you remove a huge emotional burden from your loved ones. They won't have to guess what you would want. They'll know. Take that step and you'll feel a wave of relief. You're not just planning for potential worst-case scenarios. You're ensuring that if the unexpected happens, your affairs will be handled the way you'd want them to be handled. That kind of certainty isn't just for you. It's for everyone who cares about you. If you're still here, finding value in these insights, type 2 in the comments to let me know you've made it this far. And if you haven't done so yet, please consider subscribing and turning on notifications. The more support we get, the more helpful information we can share with you. Mistake number 3, overlooking the impact of taxes on your estate. Many people believe estate taxes are only a concern for the ultra-wealthy. I'm not a multimillionaire, you might say, so why should I bother with tax planning? But estate taxes, capital gains taxes, and sometimes even inheritance taxes can still come into play depending on where you live and how your assets are structured. Ignoring the tax ramifications could mean that a chunk of what you plan to leave to your loved ones ends up going to Uncle Sam instead. A common misconception is that estate taxes are universal in the sense that everyone will pay. That's not quite true. The rules vary from state to state. Some states have their own inheritance taxes, while federal estate taxes have a threshold that changes with new legislation. However, what many seniors don't realize is that things like IRAs, 401ks, and other retirement accounts may pass significant tax burdens onto heirs if not handled carefully. Let's look at Harriet, age 73, who had amassed a modest portfolio of stocks and a 401k plan. She assumed everything would just transfer seamlessly to her children. When Harriet passed away, her son and daughter discovered that pulling funds out of her retirement account triggered unexpected taxes. Worse yet, Harriet lived in a state with its own inheritance tax, so they paid even more out of pocket. This also delayed their access to the funds, as they had to navigate the complexities of tax codes they didn't understand. Instead of grieving their mother in peace, Harriet's children found themselves scrambling to pay taxes they hadn't budgeted for. The surprising reality is that a little bit of foresight can save your family a lot of money and stress. If you've got assets tied up in retirement accounts, you can roll some of them into Roth IRAs, which have different tax implications when inherited. You can also consider gifting portions of your estate while you're still alive, taking advantage of annual gift tax exemptions. Another strategy is setting up trusts that reduce the taxable portion of your estate, depending on your financial situation. One actionable tip is to sit down with a financial advisor or an estate planning attorney at least once every few years. Ask questions like, does my estate exceed the current federal threshold? Does my state impose an inheritance tax? And would my heirs benefit if I convert some of my traditional IRA funds into a Roth? A good advisor can run the numbers and show you how various strategies might affect both your finances now and the amount your heirs ultimately receive. Think about the emotional relief of knowing that whatever legacy you leave behind is protected from unnecessary taxation. You're not only preserving more for your loved ones, you're saving them from the shock and confusion of complicated tax bills. Instead of grappling with government forms, they can remember you fondly and use those resources for something meaningful, like funding a grandchild's education or investing in their own future. Mistake number 4, not communicating clearly with family. Estate planning isn't just about writing legal documents and hoping everything plays out correctly. It's also about effective communication, something many of us tend to avoid, especially regarding sensitive topics like money, property, and end-of-life care. They'll figure it out, people often say. Or, I don't want to cause any family drama by bringing up these topics. Ironically, not talking about them is exactly what leads to drama when crises happen. One mistaken belief is that formal documents alone will prevent family squabbles. In reality, even the most detailed will or trust can't anticipate every emotional reaction or assumption your loved ones might have. Your children might wonder, why did Dad leave that vacation home to my sister? Was he mad at me? Or, why am I listed as the executor and not my brother? Without clarity, doubts and resentments can fester. Consider Robert, 69, who had a grown daughter and son. He drew up his estate plan meticulously, dividing his assets 50-50. But he forgot to tell his daughter, Anna, that he had decided to give his stamp collection, something she'd shown little interest in, to her brother, who was an avid collector. When Robert passed, Anna was shocked and hurt, interpreting the gesture as favoritism. The siblings, who had always been close, barely spoke for a year. A simple conversation beforehand, explaining his reasoning, would likely have prevented that rift. The surprising truth is that a single family conversation can do more to preserve harmony than any number of documents. Sit down with your adult children or whomever you've designated to handle your affairs and explain your decisions. Why are you leaving the house to your eldest? Why did you pick one person over another to handle medical decisions if you become incapacitated? This isn't about justifying your choices, but rather ensuring everyone understands your thinking. Practically speaking, consider holding a small family meeting where you lay out the broad strokes of your estate plan. You don't necessarily have to disclose every financial detail if you're not comfortable. Instead, focus on clarifying key elements like executors, trustees, healthcare proxies, and any personal items with special meaning. Encourage your loved ones to ask questions or voice concerns. You might discover misunderstandings you can clear up now, rather than leaving them to simmer into pain or resentment later on. Think of the relief that comes with openness. No whispered rumors, no uncertain guesses, and no frantic searching for documents when the time comes. By addressing these matters calmly and early, you give your family a chance to accept your choices and, most importantly, support each other during difficult transitions. Peace of mind often grows in the fertile ground of clear, empathetic communication. If you're finding these tips helpful and you've made it through 4 mistakes so far, type 4 in the comments. And remember, if you haven't already, please subscribe and hit that notification bell so you don't miss out on future videos. Every bit of support helps us provide more valuable insights to you. Mistake number 5, neglecting to update documents after major life changes. Change is inevitable, especially in our later years. We move to be closer to grandchildren. We downsize our homes. We remarry or lose a spouse. Yet many seniors forget that such major life events should trigger a review, if not a complete overhaul, of their estate planning documents. One key misconception is that once you've set up your estate plan, it's final. But a will or trust is more of a living, breathing document that needs to evolve as your circumstances do. There's a kind of inertia that sets in. I already spent time and money drafting these papers. I'll get around to updating them later. But later can stretch on. Meanwhile, your life keeps changing. Maybe you sold the family home or acquired a new property. Perhaps you welcomed a new grandchild whom you want to include in your beneficiaries. Or you got married again in your 70s and want to ensure your new spouse is taken care of. The risk is that your existing legal documents might not reflect your new reality. Take the story of Diane, 74, who moved states to be near her daughter after her husband's passing. Diane had meticulously planned her estate when she lived in Colorado, but now she was in Florida, a state with different laws concerning healthcare proxies and real estate transfers. She put off reviewing her documents, assuming her existing plan would still be valid. When Diane suffered a stroke, her daughter discovered she wasn't legally recognized as Diane's healthcare proxy in Florida, despite having that role defined in the older Colorado-based documents. They had to scramble at the worst possible time, filing legal paperwork while Diane was in the hospital. The surprising truth is that each state has its quirks. A healthcare directive valid in one place might not meet the requirements in another. Marriage and divorce laws can also vary, affecting inheritance rights. Even local probate procedures differ. This means you can't just rely on the universal validity of documents drafted years or even decades ago. It's best to revisit them with an attorney who understands the laws in your current state, especially after a big move or major change in your personal situation. A practical step is to conduct a life cycle review every couple of years or whenever a big event occurs. New marriage, divorce, birth, death in the family, or a major relocation. This can be as simple as a 1-hour conversation with your estate attorney or a certified financial planner to ensure all beneficiary designations, wills, and trusts reflect your present wishes and circumstances. You might also check that your durable power of attorney and healthcare directive align with your current living situation and state laws. The emotional benefit of staying on top of updates is profound. You'll rest easier at night, knowing you've honored your loved ones and protected them from confusing legal messes, and your family won't be blindsided in a crisis, forced to make heart-wrenching decisions without clear guidance from you. Instead, they'll feel your presence guiding them, even if you're unable to speak for yourself at that moment. Mistake number 6, failing to prepare for long-term care costs. Most of us don't like to dwell on the possibility of eventually needing long-term care. It conjures images of nursing homes or round-the-clock in-home assistance, and the topic can feel disheartening. But here's a stark reality. Long-term care is exorbitantly expensive, and Medicare often doesn't cover it fully. By not planning for these costs as part of your estate strategy, you risk draining assets you intended to leave for loved ones. Or worse, leaving yourself with subpar care options that compromise your dignity and comfort. The common misconception here is, if I need nursing care, Medicare will handle it. Unfortunately, Medicare's coverage for long-term care is quite limited, focusing mainly on short-term rehab or hospitalization. For ongoing care, like help with daily activities such as bathing or eating, Medicaid might step in, but only after you've depleted most of your assets. That means you could lose the home you had hoped to pass on, or the savings you wanted your grandchildren to use for college. Look at Edna, 85, who always prided herself on being thrifty and saving for a comfortable retirement. She never purchased long-term care insurance, thinking her pension and Social Security would suffice. When her mobility issues worsened, she needed daily assistance, and the costs soon outpaced her monthly income. To qualify for Medicaid, Edna had to spend down nearly all her assets, including a chunk of her life savings. The heartbreak was seeing years of careful saving evaporate in months, and her children, though they tried to help financially, couldn't prevent her from losing certain assets she'd planned to leave them. The surprising insight is that there are multiple ways to plan for long-term care without dooming yourself to financial ruin. Long-term care insurance is one option, though it's best to buy it earlier when premiums are more affordable. Some annuities come with long-term care riders. Another route could be setting up an irrevocable trust to protect specific assets, although this must be done well before you actually need care to avoid look-back penalties. Speaking with an elder law attorney is a smart first move, as they're well-versed in Medicaid planning and can advise you on asset protection strategies that align with your state's regulations. An actionable step. Research the costs of care in your area, whether it's a nursing home, assisted living facility, or home health aides, and see how they align with your current income and savings. Then explore the insurance or legal tools that can help bridge the gap. Don't forget to revisit these plans over time, because care costs often rise faster than regular inflation. Emotionally, preparing for long-term care can feel daunting, but facing it head-on can be empowering. You'll have more choices about where and how you receive care if you ever need it, and you'll protect the legacy you've worked a lifetime to build. You'll also spare your family the gut-wrenching dilemma of choosing between your quality of care and preserving your assets. If you found value in all 6 of these critical mistakes, type 6 in the comments to let me know you're still with me. If you haven't already, please subscribe and turn on notifications. It helps us keep bringing you the insights you need to make informed decisions. Now that we've discussed these 6 major mistakes, relying solely on a will, failing to assign power of attorney, ignoring taxes, refusing to communicate, not updating documents after life changes, and overlooking long-term care costs, I want to close with an important reminder. Picture, for a moment, the sense of calm that settles in when your financial documents, healthcare directives, and family discussions are all in order. That calm isn't just for you, it's for everyone who loves and depends on you. By addressing these potential pitfalls now, you're sending a clear message. My family's future matters enough for me to do the hard work today so they don't suffer tomorrow. I invite you to imagine how these changes could play out in your day-to-day life. Maybe you sit down with a cup of tea and casually mention to your son or daughter, "Hey, I've updated my will. Let's talk about what's in it." Maybe you finally call that attorney to discuss setting up a trust to protect your assets from unnecessary taxes. Or maybe you decide to explore long-term care insurance so you won't have to rely entirely on family if your health declines. The point is, each of these steps is a tangible act of love and foresight. So take a moment and think, which of these 6 mistakes am I most at risk of making? Is it ignoring the need for a power of attorney? Is it neglecting to revisit my documents after a big move or a major change in my family? Recognizing that is your first step toward a better, more secure future. If you found even one useful tip here, I encourage you to share it in the comments. Let us know your biggest takeaway or what you plan to change in your estate plan. By commenting, You also help others who might be wrestling with the same questions. If you feel inspired, share this video with a friend or a sibling who's been procrastinating about their own estate planning. You never know whose life you might save from unnecessary complications. And if you haven't done so yet, please like this video and subscribe to the channel. Turn on notifications so you'll be alerted when we release more deep dives on crucial topics like healthcare directives, retirement budgeting, and ways to stay active and engaged in your golden years. Your support truly makes a difference. It lets us know that what we're doing has value and motivates us to continue providing high-quality insights tailored to seniors just like you. Thank you for taking the time to empower yourself with this information. Remember, you have more influence over your future than you might think. By acting on these 6 points, you're not just arranging paperwork, you're shaping a legacy of care, love, and foresight for the people who matter most. I believe in your ability to make these changes, and I look forward to hearing your success stories. You've got this, and I'm here to support you every step of the way.